Dr. Rebecca Keiser. Rebecca is the Chief of Research Security Strategy and Policy at the National Science Foundation and co-chair of the Subcommittee on Research Security with the Office of Science and Technology Policy, OSTP. Rebecca was on travel, as I understand it, when OSTP gave a community briefing on October 14th. There have been many rapid developments involving OSTP and NSF since that time. Rebecca will be giving us the NSF perspective on implementation of NSPM33, the CHIPS and Science Act and related issues, and hopefully including the comments that APA Justice submitted in response to the Federal Register notice regarding biographical sketch. So welcome, Rebecca. Rebecca, at this point, would you please take the floor?
Sure. Thank you very much for having me. And I'm learning a great deal as well from the prior speakers. And so I truly appreciate this. I'm going to talk a bit about where we are with NSPM-33 implementation and where we are with the CHIPS and Science Research Security provisions. And in the course of that, I will address some of the very helpful input and questions that APA Justice has sent in. And Gisela, thank you very much as well for those inputs. We will be addressing every comment that was submitted for the common disclosure requirements, but I'll talk about it a little bit more broadly here. I also wanted to thank you for your efforts with the Hill. We, as you can imagine, interface with the Hill quite a bit. Something that was very concerning to us that was proposed for the Competes Act and then for CHIPS and Science was the Safeguarding American Innovation Act that was incorporated in at certain points in the process and then was taken out. And one of the aspects of that Safeguarding Innovation was to criminalize non-disclosure in proposals. We, NSF, were very concerned about that type of criminalization, and we argued strongly against it. It has been proposed again as part of the National Defense Authorization Act, and we continue to communicate about why we were concerned about that. So I wanted to raise that as well. Now for NSPM-33 implementation, as you know, there's one shall in there, and that's we shall pursue research security efforts without prejudice and xenophobia. Now, I am at the agency that has to implement, for good reason, a lot of the provisions. And key is not just saying those words, but how do you do that? How do you make sure that you pursue these things in that way? So a few efforts that we're pursuing. First of all, we have a JASON study out right now. And again, JASON are a group of scientists in the academic community who do studies for the federal government on the intersection between science and security. And we've asked them for thoughts and recommendations on establishing a research on research security program where we'll fund projects. And one of the areas where we'll fund research projects is better, more optimal ways to pursue research security efforts, being conscious of the risk of prejudice and xenophobia, and how can we take that into account and mitigate those risks as much as we possibly can. So we'll be getting back to you soon with what the scope of this research program will be and what the JASON recommendations are. A second thing that we're doing, and there was a question about the science article on the big data efforts that NSF is pursuing, the analytics, and a little bit about what that is. So as we hear, and the JASON report said in 2019, we still don't really understand the scale and the scope of the issues that are being caused by other governments in foreign interference in research. And so what we hope to do is use big data to analyze and understand and categorize the issues better. So what we'll be doing is comparing information that NSF has with large databases where we purchase the raw data, as well as patents databases. And this will all be done blind. So this will be done on every piece of information that we have, rather than pinpointing any particular individual. And seeing, are we finding issues that point to research security concerns? And can we categorize those better? And can we get a better idea of what the scale and scope of these are? Now, Matt mentioned the Privacy Act. To use these tools, we issued a Systems of Record notice under the Privacy Act that outlines routine uses, so how we are allowed to use the tools. We're going to go beyond that, and we're going to publicly issue what our actual process is going to be for using these tools, a step-by-step process. I would love to be able to provide that, if it's okay, to APA Justice, as well as to Gisella's group and to John, for your input and your thoughts prior to it being publicly released, and would love to make sure that the way we are pursuing these analytics is as balanced as we possibly can be. Now, let me address a couple of the other questions that we have here. So as much as a researcher tries to be accurate on a standardized form, and this is about the harmonized disclosure requirements that we are coordinating, it will never be complete. So that is very true. You know, there are always going to be things, because we're all human beings, that are mistakenly not provided on the form. I want to assure you that none of us are interested in mistakes. That's why we wanted to be as clear as possible about the information that we're requiring to be disclosed and how we're using that information. So we require the information to be disclosed, of course, to resolve conflicts of interest and conflicts of commitment, as well as to make sound funding decisions. So if there's an omission of something like, let's say, the omission of a $500 grant from a company, then there is no interest whatsoever in punishing someone because of that. What we think the analytics are actually going to help us to do is, if there are unintentional omissions that occur, we'll be able to go back to both the institution and the researcher and say, we found this, is this something that you would like to add to your disclosure, or is this something that's inaccurate and you know the tools mistakenly found this out? That's the kind of thing that we hope to find. And so there is no interest whatsoever in that type of punishment. Let me just briefly talk about the question about the article on NSDD 189. Well, NSDD 189 is a presidential directive from the 1980s that says fundamental research should remain open. There was an article that came out saying that NSF was going to be funding a workshop on potential classification of research in particular areas of research. I want to clarify that NSF will be funding an experts meeting, but it is not on that topic. There was just a report that came out from the academies called Protecting Technology. And that report reinforced the fact that fundamental research should remain open. It said that there is absolutely no way that particular areas of research can be categorized and closed in any way. We completely agree with that. That report also said that we need to develop a much more robust US government strategy to attract and retain international talent, foreign-born talent in this country. We agree with that as well. this experts meeting that we're talking about doing is going to explore both of these points in more detail. So the protected tech report said that there should be a scalpel rather than hammer approach to risk in technology. The challenge is, what does that mean? It points to things like potential unethical use of research, and that is a potential risk to look at. Again, we need to understand what that means much better. We need to understand how we really assess what potential military use might mean, and look at this in a much more subtly risk-informed way. And that's what this expert group that's going to be a public meeting is going to talk about through the national academies, while also talking about ways we could be much more strategic about international talent. The last thing I'll mention overall is something that we're focusing on now, and it is the Chips and Science Act has a prohibition on malign foreign talent recruitment programs. And it has a definition of what these malign talent recruitment programs are. I think a definition rather than a list is a positive step forward. The challenge that we have is this is a prohibition. And how do you implement that prohibition? Meaning that one may not receive federal funding if you're part of such a program. This is another area where we have to be very careful and implement this legislative requirement very carefully to avoid prejudice. And so this is something that we are focusing on through this research security subcommittee, to do this in a very careful way, where again, we'll have additional policy that we will be issuing again for public input, and welcome comments on that. And I'll stop there. Thank you.
Thank you, Rebecca, and we invite participants to submit any questions or raise any questions with Rebecca. But I'll take advantage of my position as the facilitator and perhaps raise one question with you, Rebecca. I think throughout the China initiative process for 4 years, there has been some unclear roles between law enforcement and federal grant agencies. And many of us see that usually in terms of grant applications, is start with the grant application or grant federal agencies. And yet, I think in the China initiative process, there were in some instances, not all the cases, that essentially law enforcement took the aggressive actions upfront, which eliminated the administrative process. And so it started from a criminal investigation, and therefore scientists were put in a position of only defense. And once you get to the courts, another very damaging part is that, and then nothing against Matt here, that all the legal costs can add up very quickly to very huge amounts. So through the current process, and this is sort of a long way to ask this question, how are the roles and responsibilities of the law enforcement and the federal agencies separated? Will there always be a consistent approach that if there are any violations or allegations, we start with, for example, NSF. And if there are referrals, then it goes to the IG. And if there are some determinations, then it goes to law enforcement. So is that, what is the current understanding at this point?
So Jeremy, I think you hit the nail on the head where we need to be clear about what roles and responsibilities are. And there needs to be a lot more coordination and transparency about those roles and responsibilities, as well as due process. Something that I have heard quite a bit is that it isn't clear what the role of the NSF Office of Inspector General is, and when they might choose to pursue an investigation, and then how they determine what the end result of that investigation is, and then how is it determined what action that NSF might have. I do also hear that it isn't clear then what the interaction is between NSF and Department of Justice and Office of Inspector General and Department of Justice. So something that I have talked to my Inspector General, Allison Lerner, about is we are going to start an outreach campaign together to be very clear about what the role of the OIG is, which is very different from the role of the agency. The OIG does investigations, as you know, for NSF, if there might be waste, fraud, and abuse related to NSF funding. If it is determined to be something that might be criminal in nature, they refer it to Department of Justice. To me, there is absolutely no reason why we can't be more transparent about that. Now, the challenge that I always hear from others, because again, I'm on the agency side, is certainly every case is different. And so it's hard to have one common approach to things, but we can be a lot more clear about what the process itself is, and what we might act on and what we might not act on. So I'm committed to that transparency and communicating that with our Office of Inspector General. Now, as far as interface with Department of Justice, something that we found is that Department of Justice, of course, tells us if there's something criminal, they will pursue their, whatever they need to pursue, or feel that they need to pursue. There is an increasing effort for Department of Justice to work together with our OIG and with us to do negotiated settlements with the awardee institution, to put into place something like a corrective action plan, to address what sometimes are more systemic issues related to the fact that a number of researchers might have disclosed things to the university, but it hasn't made it to NSF, for instance. Sometimes the systems that the university has in place might need improvements. And so we've seen a movement towards that type of settlement. And I think in those cases, it's a positive because we then as an agency are able to work together with the institution in a non-punitive way. In some of those cases, while we're working with the institution, there might be suspensions of some of the grants until they improve their processes, and then those grants will be reinstated. So again, we just need to be transparent, much more transparent and clear about that.
There is a question that also came through the Q&A feature, and it is NSF working with the State Department on the implementation of NSPM-33 and the Chips and Science Act?
Yes, in a variety of ways. And so the overall, there is the importance of international talent and international STEM talent effort. And NSF is working very closely with Department of State on making sure that we look at and have the policies to do things like make sure that the national interest waiver, which now includes STEM, is implemented. And any way that NSF could then work together with State Department on making sure that occurs. The second thing that we're doing with Department of State is the reason why I wasn't at the October 14th OSTP event was I was actually in Brussels. So we're working together with other governments and the European Union, and I had a Nordic country dialogue after that to coordinate more internationally on these issues. I think it's something where we need to come to some common international understandings on research security and research integrity. We've been working with the G7. We also are going to be having an Americas meeting with the Americas region of the Global Research Council to talk about these things. So this is something that I think is going to be helpful so that we take a wise, measured international approach.
Another question coming through the Q&A is, will the transparency about process be implemented by other federal agencies? That is, what role will OSTP have in assuring that other agencies that fund research at universities are better aligned in this regard?
Thank you for that. I've had many conversations with OSTP, and they do plan to raise this transparency and consistency issue through the interagency process. It's something that is it's an important priority that we want to do. I do have to say that initial discussions have met with some concern by some agencies that it's very hard to think about consistency when we have so many different agencies with different missions and different cases where there might be different approaches. I'm optimistic though, because that's the same thing that we got when we were trying to talk about harmonizing disclosure requirements. Every agency has its own mission, its own authorities. We can't harmonize. There's no way. The fact is that we're in a much better place today. I think, as you said, there's much more that we need to do. And per Gazella's point, it has to be an ongoing process improvement. So the disclosure requirements, for instance, when we get input and we implement them and we see how they work, they need to be revised accordingly. It's going to be the same with this, but that coordination is beginning.
Great, thank you. We're running up to the hour, but I do want to raise one question. When you talk about numbers, when you talk about analytics, my background is in statistics, so my ear perk up. and a question that was part of the submitted comments is about the establishment of a benchmark. So for the past, let's say 5-10 years, we don't seem to have a quantitative set of benchmarks as to how many violations or allegations are there, especially in terms of the types of a violation that you may have mentioned about conflict of mission, conflict of interest, conflict of commitment. And yet there has to be some data. We're in the data or evidence driven policy making age. So are there such a data? Will they be setting up the benchmark so that we can measure the effectiveness of the policies and practices that are being developed and will be implemented? So there's something to compare to over time. So that would be my question. Thank you.
I really appreciate that. And I just had this conversation with my research and engineering colleagues at the Department of Defense, because as you know, we have individual agency information on violations. And as you know, on the NSF website, we break it down into suspensions and terminations and debarments and things. We keep it anonymous, of course, again, because of Privacy Act. Different agencies do have these data, but you're right, we're not collating it in any way. We're not collecting it and putting it together, and we are not grouping it according to the type of violation that caused this particular consequence to be put into place. It's something that we do need to work on. There's going to be a GAO report released very soon that has some of this data per agency. And what the GAO report will also say is part of the challenge is that the violation where there's the consequence is something like, giving false information to the government, or using the grants in an inappropriate or improper way. And so it makes it very hard to break it down into research security related violations. But that's something that I'm committed to do, and something that I've done on my website, because I think we need to be clear. So I'm committed to coordinating this among the interagency. Thank you very much. I will definitely do that.
And we're running past the hour, so I'll just make one last comment. I think it's inevitable that big data, data science, and AI will play an increasing, if not dominant, part of future science and technology, if it's not already there. But at the same time, I think, as you observe, there are privacy issues. And for someone who's in the statistical area, there are also data quality issues. And then for the computer scientists, there are questions about bias in algorithms. So there are various unintended consequences. I'm glad that you mentioned earlier that we'll have a chance to look at those study framework that you mentioned. So I want to thank you for that opportunity. So with that, Stephen and Vincent, do you have any questions for Rebecca before we close?
I think that was a very thorough coverage for what you did not cover at the briefing.
Yeah.
Thank you. Thank you very much. And I will, this draft process that I'm talking about, we have it in draft, so I'll be sending it your way. And I really welcome your inputs.
Thank you. And to close, I'd like to mention that APA Justice has been ongoing with these monthly meetings for the past 3 years. So we're going to take a recess in December, if you can imagine that. So we want to wish you a happy holiday season coming up, and New Year. And our next meeting will be set for Monday, January 9th. 2023. So with that, I thank all the speakers. I thank all the participants, and my apologies for running over time, but I hope you all agree that it's very much worth it. So with that, any last words? Otherwise, going once, going twice, and have a great day.